This Item number 1 for pronouncement of judgment.
So we'll read in the
Lordship, yes.
Mr. Shulai, we have altered the charges.
Lordship.
What has been established is that the accused appellant had used intentional force without the consent of the victim, and such force has resulted in injuries sustained by the victim. Therefore, in this manner, the accused, for having committed such an offence, he is liable for punishment under Section 352 IPC, which provides for imprisonment of up to 3 months or fine, which may extend up to 500 rupees, only or both. Under such circumstances, this court hereby alter the charge against the accused appellant for an offence punishable under Section 302 IPC to that for the offence punishable under Section 352 IPC, and sentenced to undergo punishment for imprisonment for 3 months. Since it appears from the records that the accused appellant has been in custody for a period of more than 3 months, the period of imprisonment hereby imposed would be considered as term served. Accordingly, we find that the accused appellant is entitled to benefit of doubt insofar as the charge under Section 302 is concerned. The impugned judgment and the corresponding sentence of imprisonment in this regard is required to be set aside and quashed, which is done so herein. In the event this appeal partly succeeds, the conviction and sentence of the accused appellant as regards Section 302 is hereby overturned. He is now entitled to be immediately released, provided he is not wanted in any other case.
Right. Any mention?
May I please, Your Lordship? I beg to mention item number 16, my lord.
17.
My lord, I'm seeking for 2 weeks' time, my lord, for this matter, for the hearing.
On premium of the appellant, this is matter 3 weeks.
My lord, item number 17 also, my lord.
17.
Yes, my lord.
Same.
Apply, Lord.
Wait, please, Your Lordship. I'd like to mention item number 11 of the hearing list, madam. Making a prayer for 2 weeks.
2 weeks.
My Lord.
12 is also connected. Is arising out of the same.
So,
Sorry. It's a different.
okay. No, are you seeking a judgment in 12?
No. Sorry, I confused with another.
Okay. No, what this item is connected with what then?
Item number 13.
Yes, Ms. Ila.
13. Yes, it's connected, right? You should first. It's connected, right? My lord, it's not connected, lordship. It's not connected, lordship.
11 is not connected with it.
Okay.
Lordships, I beg to mention item number 13, seeking for the 3 weeks accommodation.
3 weeks, so 13.
Highly obliged.
Lordship, I beg to pray for item number 14 in the morning.
Mr. Pandit,
Pandit.
have you talked to him?
Yes,
have you
in the morning.
got his consent?
Yes, I have taken his consent. So I'm praying for 2 weeks' time, my lord.
You are there in this case?
No objection, Your Honor.
No, are you there in this case?
His senior, Mr. Pandit.
Too much senior, Your Lordship.
On payment by Mr. S.N. Gupta, additional PP, list is matter of the 2 weeks. Fine, 2 weeks.
My lord, I also like to mention item number 15, Mr. P.K. Bora. I could not see him today. So,
You have not got his concept.
no, my lord.
We'll wait, let it be called up.
Item number 2.
Your Lordship, this is an appeal which has been filed by the victim under section 372 of the, under proviso to section 372 of CRPC. My learned friend on the last occasion has raised the objection that the appeal is not maintainable. It is for the reason, according to him, it is for the reason that for filing appeal under proviso to section 372, leave of the court is needed.
No, that is not correct.
372?
That is not correct.
No, then he can just make his
372,
submission.
372, you don't need leave.
No, we don't need, my lord. I have categorically make a statement before this honorable court that my learned senior has come in under 2 provisions.
I think we are on maintainability as regard Lucas.
No, my lord. We are only on this point, my lord, that my lord, if my lord may kindly peruse 413, my lord. As per CRPC, it should have been 372. So my learned senior has filed this application under two provision, my lord, 413 and 419. But my learned senior has also made a submission that he is coming only now under 413. Now under 413, my lord, proviso, the victim has the right to file an appeal without any leave, my lord. But the fact remains, my lord, before which court the appeal lies. The appeal lies ordinarily to the court where the appeal lies, my lord. If my lord may allow me to read the proviso, my lord. Provided that the victim shall have error. Proviso of 413, my lord.
Minute.
413, my lord.
You're looking, this is BNSS?
Yes, my lord.
This is under BNSS?
Yes. The application is under BNSS, my lord.
Oh, sorry. It's very confusing because sometimes BSNS, sometimes it's CRPC.
My lord.
We are still used to the CRPC section.
No, it depends on the
Acts.
the inception of the case.
Yes, my lord. If
Please,
my lord
sorry.
kindly see 413, my lord, if I am permitted to read, no appeal to lie unless otherwise provided. No appeal shall lie from any judgment or order of a criminal code except as provided by this Sanhita or by any other law for the time being in force. Now, proviso is there, my lord. The victim also has the right to appeal, my lord. And there is no quarrel, my lord, that the learned petitioner or appellant is the victim, my lord. There is no quarrel, my lord. They are the victim, my lord. But now, where they can file their appeal, my lord, if my lord recollect, provided that the victim shall have a right to prefer an appeal against an order passed by the court acquitting the accused or convicting for a lesser offence or imposing inadequate compensation, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court, my lord. The case is this, my lord, before this honorable court is this, my lord. Trial court was the CGM, my lord. State has preferred an appeal before the session court. Appeal was dismissed, my lord, appealing the acquittal order, my lord. Now, they are before this honorable court, my lord. It applies, my lord, or we can say, my lord, it's amount to second appeal. Whether this second appeal is maintainable or not, my lord. Because the proviso is very much clear, my lord, which says that the appeal lies. The appeal shall lie before the session court, not before the high court, my lord.
Yes.
That is the point, my lord, which has to be decided, my lord.
Seems the day. What you said is correct.
My lord.
That forum is also exhausted.
Exhausted. Now,
What else?
yes.
So, Mr. Engineer, you have to
Yes.
satisfy this court under which relevant provision. Thus, another, whether it will be an appeal
Yes.
or revision or what
according to my-
are the relevant provision which
According
provides?
to my humble understanding, my lord, a revision will lie or an SLP directly, my lord, before the Supreme Court against the order of the session court, my lord. Second appeal will not lie, my lord. There are lots of judgments, my lord, that we can highlight also. That my learned senior complete, my lord.
Your Lordship, that this section 413 proviso is a self-contained provision. It gives right to the victim of a crime to file an appeal. One appeal is granted both to the victim as well as to the accused. I have not till date exercised my right of appeal provided under proviso. Now, this proviso says, your Lordship, provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offence or imposing inadequate compensation, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. Now, your Lordship, the trial court has acquitted the accused, and against the order of the trial court, the district magistrate has authorized the public prosecutor to file an appeal. Accordingly, appeal was filed, and the appellate court has also acquitted the accused. Till that period, the proviso has not come into picture. I have availed this proviso because when the state has not filed any appeal, an appeal could have been filed by the state also, but the state has not come forward to file the appeal against the order of the session judge, and victim has come before. Now, according to my friend, that this appeal is not maintainable because I have not availed the opportunity before the session judge. Now, the proviso specifically says that it will lie to the court to which an ordinary appeal lies. Now, your Lordship, I take to section 419. It is a case of acquittal, 419 of BSNL,
BNS, save as otherwise provided in subsection 2 and subject to the provision of subsection 3 and 5, the district magistrate may in any case direct the public prosecutor to present an appeal to the Court of Session from an order of acquittal passed by a magistrate in respect of a cognizable and non-bailable offence. Under this provision, the district magistrate has authorized the public prosecutor to file the appeal, and accordingly the appeal was filed before the session judge. Then clause B says, the state government may in any case direct the public prosecutor to present an appeal to the High Court from an original or appellate order. It is both. From an original or appellate order of acquittal passed by any court other than the High Court, not being an order under clause A or an order of acquittal passed by the Court of Session of Revision. So, the appeal before the Session Court has to be filed, on the instruction of district magistrate and to the High Court from the instruction of the state government. Now, clause B is not exercised by the state government. State government has not authorized the public prosecutor till date to file any appeal against the order of acquittal passed by the session court. Now, then comes, your lordship, subsection 3. No appeal to the High Court under subsection 1 on subsection 2 shall be entertained except with the leave of the High Court. Then if such an order, and he says that he agreed on the point that no leave of the court is needed if the appeal is filed by the victim of the accused. On this point, there is no quarrel.
No, I will just clarify, my lord.
Just let them finish.
No, because my senior is pointing out that I have no quarrel if the victim file an appeal under section 413. I have no quarrel on 413, but 419, my lord, whether the victim need to file a leave application or not, that I have not said anything, my lord. I'm just clarifying that part. And moreover, my lord, the leave application has been disposed of. No leave has been granted to the appellant to come under 419, my lord. There is an order that no order has been passed granting leave to my learned senior to prepare an appeal.
This case has been disposed of.
It should be specific whether the leave is needed or it is not needed.
Leave is not required, my lord, if my learned senior is come under 413. But on the last occasion, my lord, my learned senior has pointed out that he is coming under 413.
Yes.
If 413, my lord, then leave is not required. But my learned senior is pointing out 419, where leave is required.
It is for the purpose of jurisdiction, not for anything, where the appeal will lie. That is what senior counsel is explaining.
No,
you are confusing, Mr.
No.
Sit down, sit down.
Let me just point out.
You will reply.
No,
you will reply. Please sit down. Senior is on some other point.
No, he's pointing out that leave is not required. I said leave is not required if it is 419.
It's okay. We got your point.
If such an order of acquittal is passed in any case instituted upon complaint, and the High Court on an application made to it by the complainant in this behalf grants special leave to appeal from the order of acquittal, the complainant may present such an appeal to the High Court. No application under subsection 4 for the grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months. Now, your lordship, if section 413 is read with section 419, it will appear, your lordship, that appeal would lie to the High Court, because the proviso says the appeal shall lie to the that appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. Now, your lordship, they were not convicted, they were acquitted. Now, so far acquittal position is concerned, the appeal is provided under section 419 to the High Court. Accordingly, your lordship, I have filed the appeal before the Honorable High Court. I have also filed an application for seeking leave of the court, but the earlier bench, after hearing the matter, found that it is though not recorded that leave is in the case of if the appeal is filed by the victim, no leave is needed. Close the applications. No order is rendered. The application was simply closed. Because during the course of argument, it revealed that there is a three bench judgment which have stated that such an appeal, if the appeal is filed by the victim, no leave is required. So, your lordship, the appeal would lie to the High Court. Now, the other question which my learned friend is raising, that such an appeal would be only the first appeal, not the second appeal. Second appeal is not allowed under section 413. To this, your lordship, I have pointed out to your lordship two judgment. Your lordship will give me 1 minute time, your lordship. Your lordship, the first judgment is of the Bombay High Court. And the party's name is Lata Ramesh More versus Ramesh Dinkar More and others. Criminal application number 269 of 2014, decided on 3/8/2015 by the Bombay.
Yes, it's here.
Your lordship, para 23.
Yes.
वो कितना नंबर है? Your lordship will just come to para 2 first. During the hearing on some of the above application for leave to file appeal, it was argued by various respective counsels for the applicant.
You're reading?
I am reading para 2, your lordship. During the hearing on some of the above application for leave to file appeal, it was argued by various respective counsels for the applicant that the application for leave to file appeal can be entertained under subsection 4 of section 378 of CRPC, challenging the order of acquittal passed by an appellate court. Initially, considering the plain reading of subsection 4 of section 378 of CRPC, it was thought fit by the court to firstly decide this legal issue in view of there being no decision of a division bench or a larger bench of this court on this legal point. It was also thought fit to appoint a learned senior counsel for M.A.S. Kiri. Then, Your Lordship, I take to paragraph 18. Paragraph 18. The above what the arguments advanced by interpretation of the word, if such an order of acquittal, these words are the opening words of subsection 2 of section 378 and also are the opening words of subsection 4 of section 378 of CRPC. By pointing this out, it is submitted that these words indicate that such an order of acquittal is the order which is mentioned in subsection 1 of section 378 of CRPC and which include the order of acquittal by the trial court or by an appellate court. Both. It is specifically argued by learned M.S. Kiri that the words if such an order of acquittal is required to be interpreted considering the ratio of the above authority and mean to include the order of acquittal passed by an appellate court. On careful going through the ratio pronounced by the authorities submitted by the learned counsel who argued on this legal issue, and considering the research work done by the learned senior counsel M.S. Kiri, Shri so-and-so, this court holds that the order of acquittal passed by the appellate court can also be challenged under subsection 4 of section 378 of CRPC for the reasoning given herein below. The relevant provision that is germane to the issue in question is section 378 of CRPC. Section 378 1b of CRPC deals with power of the state government to direct the public prosecutor to present an appeal to the High Court from original or appellate order of acquittal passed by any court other than the High Court order under clause A, or from an order of acquittal passed by the session court in revision. This is insofar as cases arising out of the police report are concerned. Section 378(2) of CRPC deals with prosecution of appeal by the central government. I take to the last sentence. The section 378(4) CRPC provides that if such an order of acquittal is passed in any case instituted upon complaint and the High Court on an application made to it by the complainant in this way grants special leave to appeal from the order of acquittal. Then paragraph 21. Subsection 2 of section 378 of CRPC specifically use the expression original or appellate order of acquittal. While subsection 4 does not specifically use such an expression, however, subsection 4 starts with if such an order of acquittal, which expression can also be found in subsection 2 of section 378. In subsection 2, the expression such an order of acquittal is stated to be an original or appellate order of an acquittal under clause B. Then lastly, Your Lordship, paragraph 23. In view of the aforesaid reason and in keeping with the policy of the court and the intention of the legislature, it is necessary to interpret the expression such order of acquittal found in subsection 4 of section 378 of the CRPC so as to be understood as original or appellate order of acquittal. This court accordingly answered the legal point as follows. So, Your Lordship, such an order of acquittal includes both the order of acquittal passed by the trial court as well as by the appellate court. It includes both. And there is one more judgment, Your Lordship. Judgment that at serial number 5, Asian Paints Limited,
Serial 5 of what?
serial number 5.
Of what?
Have you submitted any compilation, Mr. Jinder?
Sir?
Have you submitted any compilation?
The compilation I have not submitted. I have given the list of book.
Where is that?
No, इस केस में है.
Ara?
1 minute, Lordship. Oh, yes. Why now? There are 30. The matter before us lies in a very limited compass. As noted in the introductory portion of this judgment, the only issue is whether the appellant comes under the definition of victim in terms of section 2WA read with the proviso to section so and so, whether the provision of section 378 of the CRPC would prevail in the facts and circumstances of the case. This is
You're reading para? 13?
para 30.
13.
That is on the then Your Lordship will come to paragraph 45. Paragraph 45 is relevant to Your Lordship. Furthermore, another aspect that needs to be considered is as to whether an appeal under the proviso to section 372 of the CRPC would be restricted only to mean an appeal to the first appellate court or include even an appeal to the second appellate court, that is High Court, which happens to be the case herein. We find that this is not a very complicated issue of law. We do not propose to complicate it. The language employed by the proviso to section 372 of the CRPC is unambiguous to the effect that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offence or imposing inadequate compensation and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. So even Lordship, the second appeal is permissible by the victim in view of this paragraph 45 and 46. So Your Honor, two cases I am relying. One is of Bombay High Court and one is of the Supreme Court, and more specifically para 45 and 46. That is with regard to the objection which my learned friend is raising, that the order of acquittal is by the CGM and the appellate court order is by the session judge. So my appeal before the High Court is the second appeal, and second appeal is not permissible. My learned friend says that there are many authorities, but not a single authority is placed that victim has no such right to file the second appeal. And moreover, there are two judgments, Your Lordship, of the full bench, which has specifically said that one right of appeal to the victim is granted. Now, whether that right is exercised at the stage of the first appeal or is exercised at the second appeal depends upon the facts and circumstances. So far the first appeal is concerned, the state has already preferred the appeal. So therefore there was no point for me to file the appeal before the session judge. Now, state has not preferred the appeal against the order of acquittal confirmed by the session court. And therefore, Your Lordship, I have come under the specific provisions, that is section 372. Now, with regard to Your Lordship, that whether leave of the court is needed or it is not needed, and there is absolutely no dispute that I am the victim of the incident. I am the bank and I have filed the FIR before the police, and the police has registered the case and investigated and charge sheeted the private respondent, who are acquitted by the trial court, and on appeal the trial court judgment was upheld, Your Lordship. Now, Your Lordship, on the last occasion also, I have cited two judgments, that is first at serial number 1 and second one at serial number 4. Your Lordship, there are these two judgments are of the three-judge bench. Now, the issue involved in the first case, that is Malik Arjun, it was a three-judge bench case, and majority judgment was written by Justice Lokur, and dissenting judgment was by Justice Gupta. Now, Your Lordship will come to para 9 of this.
Who is it?
No, citation, I'm sorry, Lordship. Serial number 1,
You have not given
2019.
You have not given us a copy.
Two 2019 to SCC 752.
Yes.
752. Para 9. With this background, we need to consider the question that arises before us consequent to the introduction to the proviso to section 372 CRPC with effect from 31/12/2019, the question are somewhat limited whether a victim as defined in CRPC has a right to appeal in view of the proviso to section 372 CRPC against an order of acquittal in a case where the alleged offence took place prior to 31/12/2019, but the order of acquittal was passed by the trial court after 31/12/2019. Our answer to this question is in the affirmative. Your Lordship, this point my learned friend has not raised. As a matter of fact, when the FIR was lost, at that time there was no amendment. The amendment came during the proceedings of the during the trial, but the order of acquittal was passed at the time when there was an amendment. So cause of action for filing the appeal by the victim arose only when
the issue is not before us right now.
Right now it is not there, but my learned friend is still disputing here.
No, that is, he has not raised that issue. The issue which paragraph 9 deals with.
Yes, Lord.
That has not been raised by him. That is not there.
He says it is still there. If it is not there, then it's not there. And this point is not raised. I'm absolutely correct. Absolutely. But second point is raised. The next question is whether the victim must apply for leave to appeal against the order of acquittal. Our answer to this question is in the negative.
That is how this leave application was disposed of.
In view of that, it was closed.
We have passed that also.
And therefore, so far this case is concerned, I was just pointing out that there is a dissenting judgment and there are majority judgment. And the majority judgment view is that no leave of the court is required. Similarly, Your Lordship, the second case that is at serial number 4, also similar view was taken. So leave of the court is not needed. The contention of my friend that order of acquittal should be by the trial court, and it does not include the order of acquittal passed by the first appellate court. To this, Your Lordship, I have already pointed out two judgments. You submit that the order of acquittal can also be the order of the first appellate court, and appeal would lie under section 372 of the CRPC by a victim by even not taking any leave of the court. That is, Your Lordship, my short submission.
My lord, what my lord senior has pointed out is, my lord, he is blowing hot and cool at the same time. He is either coming under 413 or 419, my lord. My lord may kindly see the petition which is filed by my lord senior is under section 419 clause 1b, read with section 413. Now, if 413, my lord, a number of time I have said, if my lord may kindly peruse the application which has been filed by my lord senior, it's 419
Yes.
clause 1b, read with section 413, my lord. Now, two things has been mixed up, my lord, but with my humble understanding, I may be corrected by my lord senior if I am wrong. 413 speaks, my lord, the right to the victim, my lord. And if the victim is before this honorable court, my lord, under 413, then, my lord, leave is not required. There is no dispute about this.
You are for respondent?
I am for the private respondent, my lord. Respondent number 2, my lord. Second point is this 419 clause 1b. If my lord may kindly produce 419.
Yes.
Save an appeal in case of acquittal. Save as otherwise provided in subsection 2 and subject to the provision of subsection 3 and 5. Clause B, my lord. The state government may in any case direct the public prosecutor to present an appeal to the High Court from an original or appellate order of acquittal passed by any court other than the High Court, not being an order under subclause A or any order of acquittal passed by the Court of Session in revision. My lord, my understanding is this, my lord. It is the power of the state government, my lord, to direct the public prosecutor. My learned senior is not in that shoe, my lord. This one limb of my argument, my lord. This provision will not help my learned senior, my lord, because the power has been given to the state government, my lord, not to the complainant, my lord. Now, if, my lord, I am permitted to read clause 3, my lord. No appeal to the High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the High Court, my lord. It's very clear, my lord. No appeal shall be entertained without the leave of this honorable court, my lord. Clause 4, my lord, says, if such an order of acquittal is passed in any case instituted upon complaint, it is a complaint, my lord, and the High Court on an application made to it by the complainant, in this behalf grants special leave to appeal from the order of acquittal, the complainant may present, the complainant, my lord, it is not a victim, may present an appeal to the High Court, my lord. This is my humble understanding, my lord. I may be corrected by my learned senior if he has any other thing. Now, my lord, the laws which has been put, my lord, in a very haphazard manner, the law has been placed before this honorable court. Now, my lord, I will rely on the Bombay High Court judgment, which my learned senior has relied, my lord. My lord, may kindly visualize, my lord, this order of acquittal has come from the CGM, my lord, and the acquittal order has been upheld by the Session Court, my lord. If my lord may kindly see Bombay High Court's judgment, para 1, my lord.
Yes.
Now, para 1, my lord, says, all this matter are taken together for decision on the legal point to the following effect. Whether under section 378, clause 4 of the CRPC, an application for leave to file an appeal can be entertained challenging the order of acquittal passed by the appellate court. Now, acquittal was passed by the appellate court, my lord. That has not been placed by my learned senior, my lord. It appears, my lord, it is the Session Court who has...
Exactly, that is the point, and that is where you need the clarification. What is appellate order of acquittal?
My lord.
Now, that is what.
No, here...
That is what we need. That is the only point.
Yes, my lord. So, what is my understanding, my lord, is this. If the trial court has convicted me and the Session Court reversed the order of acquittal, then this order will come into effect, my lord. And then, my lord, senior can rely on this judgment. Now, my lord, that will be more clear on the subsequent paragraph. I'll just take, my lord, just 2 minutes. Now, if my lord may kindly see para 10 of the judgment. Para 10, my lord. By referring to the above, an argument is conversed to the effect that the policy of the legislature was that there shall be only one appeal against the order of acquittal. If the order of acquittal is passed by the learned magistrate, in a case instituted on a police report, and for the offence being cognizable and non-cognizable, the acquittal can be challenged by filing an appeal in the Court of Session. If the direction are so given by the district magistrate to the public prosecutor in any other case, to the state may direct the public prosecutor to present an appeal to the High Court against an original or appellate order of acquittal. The exception, however, is an order passed by the High Court or an order of acquittal passed by the Session. In my case, my lord, Session has upheld the order of acquittal. It is not that the acquittal order was passed by the Session, my lord. Now, my lord, may kindly see para 23.
Yes.
Para 23 speaks about 378, my lord, not under for 372. 372 is 413, my lord. My lord, may kindly see, in view of the aforesaid reason, and in keeping with the policy of the court and the intention of the legislator, it is necessary to interpret the expression such order of acquittal found in subsection 4 of section 378, not 372 of CRPC, so as to
378 is parameteria to 419.
No, 372 is parameter to 413, my lord. 413.
I'm talking about 419.
419, yes, my lord. So as to understand an original or appellate order of acquittal, this court accordingly answer the legal position as follows. Under section 3784 of CRPC, an application for leave to file an appeal can be entertained, challenge so and so, the order of acquittal passed by the appellate court. That means the order has been passed by the acquittal court in an appellate stage, my lord, not by the trial court, my lord. My case is this, my lord, that the appellate court has upheld the order of acquittal. It's not that, my lord, the appellate court has reversed, my lord.
That is a matter of merits. Merits of the case. It's not a question of, it's not a procedural, requirement. Appellate court can pass any order.
No, but
see, appellate court can pass any order.
Yes, my lord.
Against the order of the appellate court, whether conviction.
They may convict or they may upheld, my lord.
So, either of the party,
but
either the victim or the complainant or the state government can file an appeal.
My lord,
we are
it is for the state government and for the district magistrate to authorize the public prosecutor, my lord. So this case, my lord, doesn't rescue my learned senior, my lord. The second judgment which my learned senior has pointed out, my lord, Asia Paint. Now, Asia Paint, my lord, limited, paragraph 45, 46 and 47. I'll rely on those paragraphs only.
Para?
I will just read para 3, my lord, the second half of the para 3. The present criminal appeal trace in genuines to the impugned final judgment and order dated so and so in SB criminal appeal number so and so, rendered by a learned single judge of the High Court of Jurisdiction of Rajasthan bench at Jaipur, whereby the High Court dismissed the appellant appeal under the proviso of section 372 of the Code of so and so as not maintainable. A net question of law is raised here, namely as to whether the appellant will fall under the definition of victim in term of section so and so, read with section so and so to sections 372 of CRPC, or whether section 378 of CRPC will prevail in fact and circumstances of the present case. There is no question about that they are not a victim, my lord. The matter which was before the honorable court was, my lord, whether they comes under the definition of 2WA or not, my lord. Now, my lord, may kindly see the para 45, my lord. Page 22, my lord, if it's the same page, my lord.
Yes.
Para 45, my lord. Furthermore, another aspect that need to be considered is as to whether an appeal under the proviso to section 372 of the CRPC will be restricted only to mean an appeal to the first appellate court or include even an appeal to the second appellate court, which happens to be the case here. We find that is not a very complicated issue of law. We did not propose
This has also relied on Mr. General.
Yes. What I want to point out is this, my lord. They have categorically stated, my lord, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court, my lord. The last line which they have highlighted, my lord. That means they speak only about 372, my lord, 413, where the appeal shall ordinarily lie. Now, my lord, may kindly see para 47. The proviso to, we are not concerned about the victim, my lord. They are the victim. The proviso to third line, my lord. The proviso to section 372 of the CRPC is annexed to the factum of such acquittal being by the trial court or by the first appellate court. We can see the situation, though another lens also, in the fact as at hand, acquitted by the first appellate court and not by the trial court. So the case here in this, my lord, the first appellate court has acquitted the accused, my lord, not by the trial court. And that has fallen for my lord on the first hearing. Therefore, since in the present case, for the first time, the acquittal comes at the stage of the appellate court, being a session court, in law, the right of appeal by the victim will be to the next higher level is a judicial hierarchy, which will be the High Court. So here, my lord, the case was this. In this case, my lord, the trial court has convicted, my lord. High Court has acquitted. Session court has acquitted. So they have the right to come to the High Court. But it is totally reverse in this instant case, my lord. Two more judgment where my lord senior has pointed out, my lord, is 2019 volume 2 SSC 752, my lord.
What's the citation again?
2019 volume 2 SSC 752.
This was also
relied by my lord senior. All the judgments has been relied by my lord senior. I am pointing out from there, my lord, what has not been placed, my lord. Now, my lord senior has pointed out para 9, my lord. I would like to point out para 10, my lord. The factual narrative.
Yes.
Para 10. The appellate was the victim of an attack on the night of so and so. He lodged a false information report with the police, and after investigation, necessary proceedings were taken during the before the district and session judge so and so against the accused person under section so and so, my lord. So the case here, my lord, it was the session court who was the trial court, my lord. Now, my lord, para 12, my lord. Before that, my lord, para 11 will be also very relevant, my lord. Para 11 will also be very relevant, my lord. I will rely on para 10 to 13, my lord. 10 to 13, I'll rely. I'll just read out, my lord. It's very short paragraphs. In so and so number, the district and session judge of so and so acquit the accused by a judgment and order dated so and so, aggrieved thereby so and so prefer an appeal in the High Court. My lord, it is the complainant who has filed an appeal before the High Court, and it was acquittal come from the session court. The appeal was preferred under the proviso to section 372 CRPC, but it was dismissed as not maintainable by the judgment and order dated so and so. It was held by the High Court that the proviso to section 372 CRPC came into the statute book with effect from so and so, but the incident has occurred. There is no quarrel about that, my lord. We are not quarreling. Now, my lord, next paragraph. So and so then prefer an appeal, another appeal in the High Court being so and so. The appeal was filed under the proviso of section 3784 CRPC. By 3784, my lord, not under 372. By a judgment and order dated so and so, the High Court held that the appeal was not maintainable. The view taken by the High Court was on a plain reading of section 3784 CRPC, namely that the appeal was not filed in a case instituted upon a complaint before the magistrate. Under these circumstances, so and so is before us challenging the judgment and order dated so and so. It is not contended that he has been left with no remedy against the acquittal of the accused. This submission is that one of the accused is a member of so and so, and it is for this reason that the state did not challenge the acquittal. It is not necessary for us to go into the merit of the controversy or the allegation by so and so. Suffice is to say, we are only concerned with the question whether the appeal filed by so and so under proviso so and so was maintainable or not. Now, my lord, I will rely on paragraph 66, my lord. Page 777, my lord.
Yes.
Another view expressed by this court in so and so versus State of Madhya Pradesh, this court gave what appears to be a rather expensive interpretation to the proviso to section 372 CRPC and concluded as follows. This court is of the view that the right of the questioning the correctness of the judgment and order of acquittal by preferring an appeal to the High Court is conferred upon the victim, including the legal heirs and others, as defined in so and so, under the proviso to section so and so, but only after obtaining the leave. So, if it is, my lord, 378, my lord, they have to file a leave application, my lord. So, that is why I said on my first glimpse of my argument was that, my lord, they are blowing hot and cold. They are not sure, my lord, whether they want to come under 413 or 419, my lord. Then I will rely on 67 and 68 also. Then, my lord, I will go to page 77, my lord. Sorry, my lord, para 77.
If I understand correctly,
my lord,
this judgment deals only with the locus of a victim.
Yes, yes.
Whether he is entitled to file an appeal.
Yes, and we are not disputing also. They are the victim. They are the victim.
Because this deals with that period of amendment.
Yes, exactly.
Post amendment, pre amendment.
Yes, so, and two more factors was there. That who was the trial court, my lord? Which was the trial court? Is the court of session? Was the trial court? So whether this case will be applicable in our case or not, my lord, with my humble understanding, this case will not be applicable. The last case which my learned senior has relied, my lord, Satyapal Singh, my lord. And Satyapal Singh, my lord, 2015, volume 15, SSC 613.
He has not
relied.
No.
I am not relying.
No, my lord, they have relied. Satyapal Singh, if I'm...
They are in the list, but the senior counsel has not...
But I'm going to rely, my lord.
Okay, if you are going to rely, then but don't say that he has relied.
No. They have placed, my lord. I have noted down, my lord. They have placed. I don't know, my lord, now.
He may list 100 number of cases. He may not refer to all of them.
Satyapal Malik, last case, my lord.
This is a two-judge judgment. Already three-judge bench has filed.
Yes.
Here only, my lord, there are two. I'll rely. This is a case, my lord, where check bounce, my lord. And the case was instituted by the complainant by filing a complaint. Against that, my lord, they was before the court, my lord. So this is not a case of check bounce, my lord, in our case. The last judgment I will rely, my lord, is...
So you're not relying on this?
No, my lord. Only I want to point out that this is a check bounce case, my lord.
It was not relied upon by the appellant.
The list was given, my lord. No, my lord. I'll rely on one judgment, my lord. It is of Madhya Pradesh High Court.
He has not given a list of book also.
That is Madhya Pradesh Paschim Kshetra.
Yes, yes, my lord. Para 13, my lord.
Oh, yes.
Para 13, my lord. 13. If the victim opted to approach the police authority and the case has been taken cognizance on the basis of the final report submitted under section 173 of the code and the case result in an acquittal, the victim the victim as a matter of right may prefer an appeal against the order acquitting the accused, and such an appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. Here, my lord, 372 is very clear, my lord. The ordinary lies. So this is all, my lord. So my understanding is, my lord, the case is not maintainable, the petition is not maintainable. Moreover, my lord, they are blowing hot and cold at the same time, my lord. They themselves, they are not sure, my lord, they are coming under 419 or they are coming under 413, my lord. So the matter may be dismissed, my lord.
You're there?
My lord. Obviously.
May please, your lordships. Lordship, the only point that requires clarity in this matter, my lord, for a decision on this issue before your lordships, my lord, is that, my lord, now, my lord, it is very clear that against the acquittal order of the magistrate, appeal will lie to the session judge. Against the acquittal from the session judge, obviously it will lie before the High Court, my lord. Now here, my lord, the victim, whether he is required to challenge the order of acquittal of the magistrate or that of the session judge, both are concurrent findings, my lord. That requires clarity, my lord. Once that is clarified, my lord, the forum to approach also will be clarified, my lord. And if that limited clarification is brought forth, my lord, this issue can be decided, my lord. Now, my lord, the answer lies, my lord, in the very definition itself, my lord. Where respectfully I say that, my lord, both the senior as well as the respondent number 2 did not clarify on that point, my lord. Kindly look at the definition, my lord. The proviso, my lord. 413. BNSS. If I may read, my lord.
Yes, sir. Yes.
My lord. Proviso, my lord. Provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused. I'll pause here, my lord. Any order, my lord. It does not make any distinction. The, my lord, legislative intent in this definition is not about, had it been the, my lord, legislative intent that appeal of any order of the trial court acquitting the, my lord, accused herein, then it would have been very specific. It does not make distinction between the trial court or the appellate court, my lord. Had it been so, my lord, then definitely the provisor would have said, my lord, against any order of acquittal of the trial court or against any acquittal order of the appellate court. It does not make any distinction. Rather, it says any order of acquittal. Now, my lord, since the trial court's order was, my lord, challenged by the state before the appellate court, that is the session court, my lord, and the session court also has upheld. So, therefore, my lord, the order of upholding the acquittal of the trial court by extension, my lord, that very order, my lord, becomes an appellate, the order that can be appealed, my lord. Now, the proviso of, my lord, section 413, my lord, was inserted, my lord, inserted with the legislative intent of giving a very exclusive right, an independent right to the victim, my lord, to take an active part in the trial, my lord. So, my lord, my submission is that, my lord, once there is a concurrent finding, my lord, by extension, my lord, the order that was upheld, the order of upholding of the acquittal by the trial court becomes the order that can be challenged in the appeal. Now, my lord, the victim has directly come before the lordship challenging the very order of the session judge, my lord. Look at the prayer portion of the appeal, my lord. So, therefore, my lord, taking together the, my lord, legislative intent as well as the very definition which does not make any distinction between the acquittal order of the trial court of the appellate court, my lord. Rather, it has kept it as a broad definition, my lord, that includes both the acquittal order of the trial court as well as the... Now, kindly, my lord, we have to... A man of common prudence will understand, my lord, that once the state had appealed before the session court, my lord, session court has already spoken its mind, my lord, has come to a finding. Now, my lord, will it serve any purpose for the victim to approach the same court who has already spoken his mind, my lord? So, therefore, my lord, to come to a specific finding, my lord, which is the proper forum for appeal, my lord, referring this instant appeal, my lord, the very definition says that, my lord, any order of appeal, any order of acquittal. So, any order of acquittal means, my lord, since the session judge has already given a finding, my lord, so therefore, rightly the appellant has approached the, my lord, right forum, my lord. That is my respectful submission, my lord.
I need to reply, my lord, on this because the state has argued in favor of the...
Definitely, because it is kind of my second appeal, my lord. I had filed a first appeal, my lord.
They could have also filed it, my lord.
That is, we did
so
not.
let me clarify.
Yes, you can clarify. No, don't put any allegation.
No, I'm not putting allegation, but this was what I could have understood English, my lord. That the submission made by the state, my lord, is in favor of the appellant, my lord. Yes. So I have to clarify. If both the senior allows me, my lord, I will submit, my lord. My lord, may kindly again produce section 413, my lord.
First, you just have to explain to us what does the expression any court means.
Any court means, my lord, it is not the appellate court. They are not saying that it is an appellate court. Otherwise, the legislation intention would have been an appellate court also. They could have
trial court also, my
lord. It could mean anything.
Any court.
What I am saying is court, my lord. They have not even said that it is an appellate court. That we have to read it as an appellate court. It is for this honourable court to interpret, my lord, this section. My humble submission is this, my lord. A letter was written. If we go to the merit, just for 2 minutes, my lord, I would like to take, my lord, to the merit of the case also. The appellant has filed an application before the state government, my lord, requesting them to file an appeal. They have not filed, my lord, but they are supporting the case of the appellant before this honourable court. Now, what I can understand, my lord, is this, my lord. Any judgment or order of the criminal code, my lord, it is not that, my lord, they are saying trial court order also or an appellate court order also. Otherwise, they would have crystal clear written, my lord, the trial court order or an appellate court order. Any other court may be, my lord, any court, even the session court also. The intention of the legislation may be the session court also. So they have specifically said, my lord, judgment or order of a criminal court. Judgment and order. The order of the session court, which upheld the order of the trial court, is not an order, my lord. It is a judgment. Judgment, my lord. Now, if the intention of my learned senior, both the seniors, is this, my lord, the case, the victim has the right, there is no doubt, victim has the right under 413, my lord. But this point was neither argued by the appellate, my lord. That was not the case. Moreover, there is no averment made by my learned senior in his petition that the trial court or by the session court who has upheld the acquittal, my lord. There is no such statement, my lord. Now, if state want to project a different case, my lord, then, my lord, I have nothing to say.
The prayer portion is very clear.
Okay. You have heard the parties.
Your Lordship,
What else is there?
only one thing. The principle of merger also would apply here. Your Lordship, that the judgment of the trial court is merged with the judgment of the session court.
You have heard the parties.
That's what my learned friend has also said.
Yeah, I have nothing to clarify.
Item number 3.
Paperwork ready?
Paperwork is not yet ready, so matter may come up after 3 weeks, Lordship.
Mr. the OPD, learned legal aid counsel has submitted that the paperwork is not yet ready and has prayed for some time for the same to be filed in court. As prayed for, this is matter up to 3 weeks.
Item number 4.
Lordship, in item 5, the service is complete, Lordship. So the matter may be listed for hearing.
Please, Your Lordship. Your Lordship, I'm entering appearance on behalf of respondent number 4, Your Lordship, which is the Lingdo Himanong Plang. Mauplang. We will execute our power within 2-3 days, Your Lordship. I'm praying for 3 days.
Has it come up today for service report?
No, Lordship, it seems on the last occasion the council had appeared. So now it seems like there's a new council.
Yes, we were freshly appointed just this morning, Lordship.
Oh, you are freshly appointed?
So,
for
Lordship, the service,
Respondent 4,
service is complete in that manner.
She has entered appearance.
Lordship.
All the respondents are in attendance.
Are represented, Lordship.
Miss Learned Counsel has submitted that she is entering appearance on behalf of the respondent 4 and has sought for time to file the power. Accordingly, this matter will be heard after 3 weeks.
3 weeks.
Your Lordship, if it may, if 1 week, Your Lordship.
Why?
Your Lordship,
Of the matter, Your Lordship, with respect to election of the headman.
Lordship, there's no urgency. He has been removed. Now the acting headman is in place, Your Lordship.
The impugn order.
There's no urgency.
Yes, yes, no.
The impugn order, Your Lordship, they are dissatisfied of the election which was held, Lordship, and as per the order of the impugn order of the district council, they have given direction to hold the election. So that's in the crux of the
What is this for holding of election?
Election, Your Lordship. Now acting headman is in place, Your Lordship. He's the headman who has been removed, Your Lordship. Lordship.
Acting headman may be in place.
Lordship.
Who are you?
I'm the one of the contesting candidate, Lordship. Because at that time, Lordship, the elections was already conducted. I had participated now.
So by virtue of the district council order, Lordship, that election has been set aside, Lordship. So a fresh election has been held. So now we're challenging that order passed by the district council, Lordship. So Lordship, the single bench had upheld the order passed by the district council, Lordship. So now we are challenging that order.
Your Lordship, I was a removal headman at first instance.
Then,
So he never.
how will this whole process affect you?
Lordship, even if I'm the candidate, Your Lordship interested.
Lordship, he never filed his nomination application also, Lordship, to the election.
Why have you arrayed him as a party then?
Lordship, because at the application made by the respondent number 5, Lordship, the impugn order has been passed, Your Lordship. Because he had challenged the election process before the district council, Lordship. Now, by virtue of that, an order has been passed by the district council.
Who has been elected as the?
Lordship, the election has been kept in a sealed cover by the order passed by the learned single judge. Then thereafter, Your Lordship, then the learned single judge had directed for a fresh election, Your Lordship, by virtue of the district council order, Your Lordship. So now we are challenging that order. We are saying that cannot be maintained, Your Lordship, because the elections are already underway and the elections are already conducted and it kept in sealed cover, Your Lordship. Now at the behest of the respondent number 5, who even never filed his nomination papers, Your Lordship, a fresh election has been.
Have you challenged his locals then?
Lordship, we had filed a. Lordship, we had challenged that, Lordship. We had also filed a rejoinder as well. So Lordship may hear it after 3 weeks, Lordship.
Your Lordship,
Okay,
as
then
of at present,
2 weeks then.
Item number 6.
Wait, please, Your Lordship, in this matter, we are supposed to get the papers book, my lord, but the paper book is not yet ready.
We already received a copy of the paper book, Lordship.
My lord, I have not received any copy.
Paper book has been furnished to the learned council of both parties. This is the office note.
But I have not received the copies, my lord. I have not got.
Itu. Ini juga code ni juga. Ini juga code. What is this? No, but she has to get it from the registry. No? Okay. Yes, only one person has received. It appears that paper book in this matter is ready. Accordingly, matter is to be posted for hearing after 3 weeks. In the meantime, you get the paper book.
Yes, my lord.
Because she has got it, we have got it. You just go to the registry and get your copy.
Oh, yes, my lord. Highly obliged, my lord.
Obliged, my lord.
Item number 7.
Sanutli masa. Huh? Sanutli. Who's there in 10?
Appellants, no one's there.
Yes, ma'am. Have you started?
Yes. No. No, not yet started, Your Lordship.
So, what do you say?
We'll have it some other time, my lord, because we have got already one matter in the second half.
What's it depend?
But the matter has been pending for too long, Your Lordship.
What is the period of a sentence?
Period of sentence, rigorous imprisonment for life.
Life?
Yes.
Life? Oh, sorry. I thought I'm thinking. Okay. Is it POXO or
No, no.
302?
302.
302, then it'll take some time.
Yes, will take.
Next week then?
Not sure.
On premier by the parties, this is matter after 1 week.
Have a good day.
Item number 15.
My lord, the criminal investigating machinery was set into motion in this case by a missing report. Which was filed on 13/10/2016 at Nongpo police station. The missing report, my lord, will find at page 1 of the paper book. Unfortunately, 19 members.
Any mention?
Please, Your Lordship. Lordship, I beg to make a mention of item number 9, Lordship.
What is this matter about?
It's with regards to promotion, Your Lordship.
Hmm?
Promotion.
Promotion?
Yes, Lordship.
Lordship, I'm praying for 2 weeks time.
On pre-made by petitioner. This is matter of 2 weeks.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 10, my lord.
No objection.
On pre-made by the appellant. This is matter of 2 weeks.
My lord, item number 8 also, my lord.
Eight.
Yes, my lord. Here I mean,
All matter. Why?
my lord,
You are there.
Yes, Your Honor.
You can start.
No, I didn't receive any instruction regarding this matter, Your Honor.
Instruction what said?
Regarding this matter.
No, you are appearing. You are in for the petitioner, isn't it?
Yes, I'm appearing on behalf of my senior counsel, SP Mahanta, Your Honor.
On pre-made with parties. This is matter of 1 week.
With pleasure.
Your Lordship, I beg to mention item number 12.
On pre-made by the appellant. This is matter up to 3 weeks.
Highly obliged.
Daily list item number 1.
Yes. None appears for the parties. This is matter after 1 week.
Item number 2.
Lordship, in this case, I want some time for filing an objection because there is some suppression of material facts, Lordship. That is why I want to submit all the documents regarding this case, Lordship. 3 weeks time may be granted for.
You're appearing for respondent 2.
Respondent number 2. And I have not received a miscase.
State is. Yes, you have for state.
We have not received the copy of miscase, Lordship, filed on 19 of 25.
Yes, there's a miscase.
Miscase for stay is given.
But it is required, Lordship.
No, naturally, true. You, Mr. Devna?
Yes.
You give a copy to the parties.
Both the sides, they also did not.
They've given, I've given them.
Single told me I have not received.
Before this matter is taken up,
This one copy I
Ms. M. Dev, learned counsel for the respondent 2, has sought for some time, has made a prayer for the respondent number 2 to be to file a response to this petition. More often than not, in a criminal, in a revision petition, response or affidavit is not required, except since it's a matter of record. However, since the learned counsel has submitted that there is evidence of suppression of material facts by the petitioner, accordingly, as such, pre-made is allowed. let the response be filed within the next date fix with advance copy to the petitioner, who will find a rejoinder if so required within the matter to be taken up after why 3 weeks?
After 3 weeks, Lordship. Maybe fix the date, Lordship. 12th or 8th or 12th, Lordship. December. 12 already. And 15, Lordship.
So long. We'll fix it on 1st then.
11th.
1st December?
1st December difficult, Lordship, but 3 weeks time after 8th of December, Lordship. I have some matter, some inconvenience in Guwahati, Lordship.
So 8th. Please, this is matter on 8th.
Obliged, Lordship.
Item number 3.
6.
Ms. Learned Counsel for the respondent has sought for some more time to file the affidavit in opposition. Mr. appears for the petitioner. Pre-allowed, this is matter when?
Your Lordship, 3 weeks.
Matter after 3 weeks.
6 and 7 are connected, Lordship.
2 7 should at least matter after 3 weeks.
Item number 11.